Oh, your thing's right there, Rick. Those are his things right there.
No, I didn't. It's not here.
Good morning, sir. Hey,
I'm hoping
Are you here for the municipal council?
Yes, I am.
You don't look like Charlie.
Everybody know everybody? I don't say welcome.
your mic.
Thank you. I stand corrected. I want to be absolutely firm with all of you. This meeting is about process. It has nothing to do with individual MOA applications. And for reasons of litigation and all sorts of other good reasons, we will not entertain a single comment on it. I will gather you down if you talk about any specific MOA applications. Everybody got that? Clear? We're here to talk about process. It's a process that the commission adopted or failed to adopt, I would say, in the past. It's a process written into the rules, but with no accompanying direction. So the whole charge of this committee is to discuss how we conduct MOAs. We have agreed, I think, totally, that the MOA, the fact of an MOA is needed, that we really need a mechanism by which public agencies can meet the needs of the public in occasions when it can't be done in any other way, and there is equal protection for the Pinelands to balance any deviation. Now, I want to say also, there are lots of different kinds of agreements. The one we are interested in here are the deviation agreements, which means that the governmental agency can't meet the absolute requirements of the CMP, that comes to us with a proposition in which I don't dare say the word compelling, because Stacy will correct me, but the public need is met, and but can't meet every provision of the CMP. But that there is equal protection for the Pinelands in some other way to weigh against that. Now, have you all read absolutely everything I sent you? Absolutely. I mean, you have found a lot of stuff in there, I know, but I think almost the most important one is the one that discusses the goals of both the Act, the Federal Act, the State Act, and the CMP. And those goals are what we're trying to meet. in everything we do. So I think it's important, put them somewhere where you can look at them once in a while, and because it will be the test of what we do. In regards to public comment, we welcome you to listen and are glad you're here. I'm particularly glad you're here. However, I will hold you to 3 minutes because I would much rather have your comments in writing than verbally. So if you can hold yourself to 3 minutes to summarize what you might be writing and giving us in written comments, I would very much appreciate it. It's very hard to assimilate all the things that everybody's trying to get across in their verbal comments. Much better to have them in writing so that we can really digest what you have to say. And once again, this is not about individual MOAs that we've done in the past or the future or any other time. This is about process. And I will have to sit you down if you bring up any of the other, anything else for the process. And with that said, one of the things I sent you was a review we did about 2007. And we went through all of this because both the public and ourselves had very much of the same kind of concerns as arose during this plan review. And therefore, I thought it would be helpful if Susan went through the previous review and got you up to date on what we didn't do.
Would I be remiss in saying it would be really helpful to me if we went around the table?
Okay.
I don't know all these people, unfortunately. I'm new to the
All right.
game.
We'll start with Tiffany.
Hi, I'm Tiffany Cuviello. I am representing the Pinelands Municipal Council.
I'm Arnold Fishman, Medford Lakes. I think I represent the public interest.
I'm Fred Akers. I work for the Great Harbor Watershed Association, and I've also resided in the Pinelands for 30 years plus.
I'm Paul Galletta, Atlantic County's rep to the commission, Pinelands.
I'm Ed Lloyd. I've been a commissioner since 2002, and I hope I represent the public interest as well.
I didn't mean exclusively.
I didn't take it that way.
I'm Candy Ashburn. I've been around since 1979.
Been around here since 1970.
I'm Alan Avery. I'm Ocean County's representative to the commission. I've been around since 1982 with a short break of 5 years.
And I'm Ernie Colwine. I'm the solid waste director for Ocean County.
And Ocean County appointment, I've been around since 1950, that's when I was born. With a short break. Not so big, I forget about
Sue Brogan, I'm the commission's chief planner since 1988, if we're doing it. 88.
Larry Liggett, also with the commission since 1988.
Nancy Wittenberg, Executive Director, Pinelands Commission, 2011.
Chuck Horner, Director of Permitting for the commission.
Rick Perkins, commissioner, interested in hearing firsthand what the community is doing.
Yes.
Kristen Heinzling, DAG. I'm actually leaving this assignment, and my replacement's here to kind of get his feet wet and meet everybody.
Sean Moriarty, replacing Kristen, Deputy Attorney General. I've been here for like 20 minutes.
That's good.
Paul Macon, the Commission's Communications Officer. I've been here since 2005.
And Betsy.
And I'm Betsy Piner. I'm the planning assistant who was hired mostly because of my surname.
Thank you.
I see. You can have 2 votes. equal?
I'm an alternate.
That's what I mean. Your chief guy is here.
I have the alternate vote.
Right, Alan's a commissioner alternate, and Ernie's a county rep. Right, they serve two different functions. Alan's a commissioner alternate. Ernie's a county rep, just like, Arnold's the public alternate to Fred. That's how Mark set it up. Don't you
So
forget.
if one of the commissioners is absent.
Right, that's right.
Okay.
He's not fighting with Ernie.
Okay, I'm not gonna argue with
Okay.
anybody.
All right, so you, Katie, you had asked Susan to go over the 2007 John Stokes memo.
Yeah.
I just want everyone to know, John pretty much did this independently of staff. So Susan and I can now try to sort of go through it and talk to you about it, but I think she, as much as we can talk about it, if staff didn't participate in the drafting of it, so Susan's now like,
No, but the
Okay.
commission itself did participate in this discussion
Right.
with our executive director.
Right.
Right.
And Susan is more familiar with it than anyone.
Yeah, I mean, I can talk a little bit about the prior, what Candy was referring to in 2007. That effort grew out of an MOA, Memorandum of Agreement, that the commission entered into with Stafford Township to allow for closure of the landfills, redevelopment of the business park. That MOA was ultimately signed, and but it raised a lot of the same issues that the commission has been dealing with recently in terms of agreements and who should be partners in the agreements, and is it a public development, is it a private development? A lot of the same issues that the commission is wrestling with today were brought up by the Stafford Agreement and led John to put everything down in writing about the history of agreements, when they were first authorized in the CMP and why. You'll see in his memo, he goes through a listing of agreements that had been approved by the commission at that point in time, another list of those that were pending, some of which the commission later did enter into, and others of which never came to fruition. So, he has a fairly comprehensive listing where he tries to talk about the topic and what it was about, and what the agreement was for. He talks a little bit about the public-private nature of these past agreements, and he, I think, goes into some detail about who all of the past agreements were with. I actually have a lot of that information in a PowerPoint that I can either show you now or later if you're interested in looking at sort of an overview of past agreements and who they were with and what they authorized and what the offsetting measures were, the equal protection measures that Candy's talking about. I can show you a little of that, maybe rather than trying to go back through all of John's memo, because it is pretty detailed. He does at the end of the memo include some suggestions or possibilities that the commission could consider to change the regulations that govern MOAs. And that's what was provided to the P&I committee back in 2007. And the committee then met a series of times throughout that year to wrestle with the issue. We included the minutes from those meetings or excerpts from those meetings in your packet so that you could see. I think what it shows is that the issues are pretty much the same. They haven't gone away. The committee discussed much the same issue. They discussed public-private, they discussed offsets, they discussed all the different things about MOAs. They talked about changing the rules, defining what public means, all kinds of things. And at the end of that sort of year-long process, the P&I committee decided that at that time, changes were not necessary to the regulations. And what's in the regulations is separate from, Candy's talking about process. We have a written process. Paul's showing it on the screen, although I have to tell you, Paul, you really can't. I can't read that from here. Maybe we turn the light up. But that's also in your packet, is this process that was
That's
developed.
the 2014 one.
Right.
We're talking about the earlier.
Yeah, but this came from, this was first developed many years ago. An internal process for the staff and the P&I committee and the commission to follow. That also sort of came from all the information that John was providing, and the committee reviewed this process. And all the steps of the process are not in the regulations. A lot of it is, when do you bring something to the committee to discuss? What materials do you need? Who talks to the committee? How decisions are made? The regulations themselves have little in the way of process other than a requirement for a public hearing. which triggers certain notice requirements and then action by the commission. So most of the process you're seeing is separate from the regulation, but it's something that I know Candy wants you all to talk about today.
I have a question, do I have the understanding correct that the deviation MOA was not included in the original CMP and didn't
That's
get
correct.
added until
That's true.
1994?
That's
which
correct.
is like 14
That's true.
years
Yeah.
later?
And that's sort of the first part of John's memo is, that those provisions were added in 94 through amendment by the commission. Prior to that, really the only avenue that a public agency had was the formal waiver of strict compliance process based on a compelling public need. The commission has approved a number of those waivers over time. But in 94, the commission amended the regulations to specifically authorize several types of agreements. One are we call streamlining agreements, they're application processing, but also what's come to be called, although the regulations don't say this, but deviation agreements were put into the regulations and provided some framework and some standards for the commission to use when considering these requests.
One of the reasons was, Fred, is because proving compelling public need was so difficult, among other things, and it was just not very practical
So the
not to
board-
have a mechanism for public agencies.
Okay, so what you're saying is that the waiver of strict compliance proved to be a problem over in the beginning years?
Yes, it did, and became very difficult to implement in a way that everyone even could agree. Yeah.
Is there a public and government programs committee?
Oh, there was for many, many years.
But the P&I now does what that did.
Yes, we combined committees to try and get things.
So the original
Thank you.
process is written as though the Public and Governmental Programs Committee would be dealing with proposed agreements. And that's several years ago.
And it got folded into the P&I, so,
Yeah, I assumed that, I just wanted to make sure.
yeah.
I was
no,
on the right
You're right,
Okay.
that's true. Are there any other questions from Susan about where we've been? One of the things that I would like to stress is that the commission, we all assumed that the process would go as the way it's written here, but we never adopted it as a process, in the sense that the commission did not take action saying, this is how the process will work. So even though this is how the staff has always used it, and this is how we've all assumed it, it's not an adopted resolution or rule or anything. It's just the practical way of applying what we have in front of us. So, are there any other questions?
Kenny, could I just ask one question of Susan?
Yeah.
The provisions for the MOA were adopted as part of plan review
Yes.
or separately?
It's part of a large set of amendments.
Correct. So it was not something individually adopted, it was part of a whole series of
In 1994? is that-
Right, it would have been, I think we probably called that the second plan review, and there was a big set of fairly significant amendments that the commission adopted
It
at that
probably
time.
started in '85.
Yeah.
Any other questions? Would you like to go through that procedure in order to see how that works? And ask any questions that anybody has. The one I have is dated the 23rd, June 23rd, 2008.
Right.
Is that the one we're currently?
Right, except the names of the committees have been changed.
No, okay. Forgetting that.
That's still the process.
But these steps are basically what, if the staff had to deal with an MOA right now, tomorrow, it would be, these would be the steps you follow. So, I think there are several concerns, at least I can tell you mine, just so that I can start the conversation. My concerns involve, A, having a procedure that has been adopted by the commission so that we can all get on the same page. I think the other one is the commission's involvement early in the process. The other one is the question of the public hearing. I don't think 10 days is a good notice period, and there might be a way to change that. There certainly needs to be, the executive director conducts the public hearing. We might want to talk about that. The question of equal protection, there are no standards anywhere for what constitutes equal protection of the Pinelands resources. And whether there's something we can make that more explicit or not, I'm not sure. These are all just questions. I'm not saying that I have a proposal to solve them all. And I think that's the worst to find. It would be helpful if any of you who have concerns could put them on the table just so we can spend the next month thinking to ourselves individually how we're going to address some of those questions.
Mr. Chairman, I think one of the most important parts that I would like to get concrete in my mind is who is a suitable applicant. I know we say it's an NGO and a public entity, but could we go in detail without getting into unnecessary process?
Yeah, that's always been a question.
That's always been a question, but if we could clarify that, I think that would be a good start in my opinion.
I agree with you. It's like having standards for equal protection. It's just a little bit too far. You think we need to see?
Yeah. Yes.
Let there be light.
Yes.
Anyone else have anything that, just from the reading you've done already, I won't hold you to it. You have any?
Yeah, Madam Chairman, I would echo Commissioner Gilletta's concern.
Yeah.
I think that it's important that it's clear that who's eligible to apply, and I also think it's important that we continue to allow public regulatory agencies that have jurisdiction over projects to be an eligible entity, as we have in a number of times in the past. I think, in fact, most of the MOAs have been with that kind of agency. I think if that's clarified, that eliminates some of the concern about process. And I think we also need to be sure that we have a clear understanding of the types of participants that would be party to an MOA, whether they're private entities that are working to implement the larger public purpose or not. And particularly, I think there's a distinction in my mind, and I hope there is in others' minds, between what is a regulated public utility, which is a special type of business in the state, versus a profit-making entity business that we heard some comments about. And those would be, and the third is kind of a strange one, Candy. One of the reasons we have the MOA process is because of the difficulty of meeting the compelling public need waivers requirements. And maybe if the commission took a look at some of the most onerous restrictions, and there's one in particular that makes it almost impossible to qualify for a compelling public need, with the exception of existing linear development. That might help keep projects within the context of a plan application or without a deviation MOA.
Understood.
Good.
Andy?
Yes.
Yeah, I too share Paul and Alan's sentiments about who should be able to qualify to present an MOA or MOU, however you want to word it, to those types of organizations such as public utilities. They're the ones who provide, the basic needs of the communities. It isn't the towns, it's these public utilities. So I think it needs to be clarified in this process that those agencies should be able to make an application as well. If there isn't enough language in there as it is. I'm not going to get into that debate over this.
Yeah, and most of what I hear and most of what I think are really clarifications of, and some of them are things we've been assuming, individually assuming that weren't sort of par for the course. So I think we need to address that kind of thing. Who else? Okay, Fred.
I was struck with John's report in the discussion of public purpose, that there was like no limits defined for what the public purpose might be. And I think that needs to have some definition. So, even something as simple as public purpose in the Pinelands. So if we had a public purpose outside of the Pinelands, which is, could be a wonderful public purpose, is that the jurisdiction of this commission to judge all public purposes, or should there be some, kind of framework that says public purposes within the Pinelands or within the jurisdiction of the Pinelands Commission?
Okay. Who else?
I'm just getting acclimated.
Yeah.
I certainly share a lot of the concerns that have been raised already. I'll try not to repeat them all. I guess one of my major concerns is the question of the standard of equal protection in the Pinelands. I think that there is no definition to that. I think that it invites arbitrary action, and I think exposes us to challenge based upon an arbitrary action. I certainly think we should address the issue of who is eligible. I lean frankly against the public utility being eligible because I think that's open to abuse. And I think back to what Jerry Jacobs said, who's, as most of you may know, was the chair of the commission and also the chief executive officer of a public utility, and said that he thought that one of the greatest dangers to the Pinelands was its use as a corridor for public utilities and other linear development. Having said that, I think we need to clarify then who is eligible. I think we create a fiction when we say that the Board of Public Utilities acts in lieu of the utility. If we're really going to consider utilities, maybe we should allow utility to enter into these MOAs. As I said, I lean against that, but let's not create a fiction that a regulatory agency comes in the place of a private applicant. I agree with Candy about the Commission's involvement. I think we need to be very involved in when we're going to undertake an MOA process, because it's an enormously time-consuming process, and I don't want to burden the staff with that duty without making sure the Commission thinks that it's an appropriate way to go. I hadn't thought about the 10-day notice of the public hearing, but Candy, I think you're right, we probably need more notice than that. Those are probably my major concerns at the moment. Thank you.
Anybody else? You didn't read here. You did. You did. That's very helpful, I think. We need to clarify that list for you so that I'm sure Betsy's minutes will be explicit. And that way we'll be able to know the things that we need to address. I think that there are questions in my mind about alternative solutions to a problem. And I think that has to be clarified also. It's not a question of this way is more expensive, this way is less expensive, or whatever. We need to, seems to me, clarify what we are trying to do in the way of meeting compelling public need and what is compelling public need. And I think in the course of working on this, we'll find our way through that morass. None of this is going to be easy, as you all must know by now. Because, among other things, I remember with one discussion of either, it could have been one of the other kinds of agreements, but the issue of impairment, and we finally defined impaired wetlands, but there may be some other things that we have to clarify so that they don't rise up at the wrong time, that they are automatically out of the search area. So I do agree with the issue of linear development. Pinelands Federal Act was passed in order to avoid having linear development go across the Pinelands just automatically. Obviously, it was a cheap route, and at the time, it had to do with taking oil from offshore drilling and taking it to the refineries on the Delaware. But there are lots of other reasons people want to build across the pines because it's cheaper, supposedly. In addition to that, when you put the goals of the Pinelands Protection Act up in front of you, some of these issues become very obvious that they're a problem. The question is, how do we solve it? And how do we deal with that? And so I see this committee not meeting a whole lot of times, thank God, but basically getting some work done on these very issues that we put on the table. So I'm going to use this list, and if we can solve even half of them, we'll be much better off. I foresee hopefully not changing the rules. That takes a year, and I don't think, personally, I never plan a year ahead at this point in my life. So I think that what I would like to do is to create a process that is adopted by the commission as being the process and answering some of our questions that you've just raised in that process, and not having to go through a huge rule change. We may, in the process, get to a point where there is a rule change, much as John suggested, some, and there are others, I'm sure. But let's work on the process first and get answers that we're satisfied with in dealing with each of these questions. And so in order to get you to come back someday, I'm going to just move on to public comment, and unless anybody...
I have a suggestion.
Yes, where are you?
Over here. Can we get Larry to maybe make 3 models of equal protection? And that we might be able to discuss at the next, this has got to be the hardest thing to come up with on equal protection.
I actually graphed the ones that we've used so far, and there's 5 models.
You've got 5.
One of the things you're going to see is, and Susan's pointing, at least 5. In many cases, it's hard to apply an old model to a new situation, and sometimes you just have to have a model for that particular situation. So I do have fact, I have a PowerPoint, I didn't bring it with me, but
For next meeting, maybe,
Well, what I was thinking, maybe the next
Could we
meeting
call
we'll
it
have a
equi-
meeting with our staff without the public, so that we can have a discussion and suggestions from the staff. And I can do that, can't I? Yeah. And so rather than
Could we call it equivalent protection instead of equal protection? Equal protection till a lawyer makes their ears stand up.
anyway.
Well, equivalent protection has the same effect.
There are issues here that I'd love to have an opportunity for us to meet with our own staff about that they can't necessarily discuss in a public meeting. So I think I'll have, the next meeting will not include the public, so that we can have that discussion, but we will certainly bring everything that comes out of that we want to talk about to the meeting after that in public. So, is that all right, Nancy? Can you arrange that so that at our next meeting, which is May?
You're going to stick with, you want to do it after P&I again? or-
Yeah, right after the P&I. Is that all right with everybody?
If you come closer to the start time, the planned start time.
Well, that's no plan start.
That's-
Yeah, 10:30 or 11.
That's the
I
problem.
can't-
I never get public comment.
I never said a start. What's the date?
What is the date?
Beth, you know when the next P&I is? I do not, I'm sorry.
May 29th?
I will get that in a moment.
That sounds great. Can I ask a question?
Yeah, that is right. It's a piece of, the piece of P&I is on the
May
29th.
29th.
No, 9th.
Yep.
So that must be Memorial Day.
No,
Sometimes it is,
Memorial
sometimes
Day
it
this
is.
year.
Memorial Day weekend's the
Is there
early.
a previous week?
Memorial Day is the Monday of that same week.
Okay, so that everybody be aware, and that meeting will not be public, and the following meeting will. Okay, everybody?
Can I ask a question?
Yes, of course.
I wasn't clear on what you meant by impaired wetlands, and that, I'm not sure. You meant
Well,
that, just
in
clarify that.
in the course of doing some of the MOAs over time, the issue of what's impaired and what isn't came up, and nobody could describe it. And we have a definition. It's defined in the plan, correct?
Yeah, I think maybe you're referring to, Candy, the commission adopted a new set of waiver regulations in 1992. And as part of that effort, the term substantial impairment was defined, so that there are objective standards. And a definition for impaired wetlands was adopted at that same time, I believe. So that has informed the waiver process, at least. Waivers of strict compliance can't be granted if they would result in substantial impairment. That's a term that's been used, was used for many years before 1992, but was not explicitly defined. And so maybe that's what Candy's referring to, is that's a similar effort that was done, it's in the rules now. And now you have this other term, this equivalent protection term.
Yeah.
And maybe you're talking about.
So I'm trying to figure out
something
how to get
similar.
these to
Right.
go together and not be at odds.
Thank you.
I'd like to
I
maybe,
thought I sent it to you, but maybe
I
not.
may have missed that.
I'd like to just support the chairwoman in her position of not changing the plan. I found it very compelling that in the 2007 pitch by Executive Director Stokes to change the plan for the MOA process. And he was a very persuasive personality, and for the commission to decide not to change the plan at that time, I don't think we need to go down that road again. I think clarification, some kind of agreement should be.
I hope you're right.
If I may, I may make a mess, sorry. I think there may be a legal issue about,
Yeah.
Look at what you.
yeah, it depends on what process we adopt that may determine whether we have to change the plan.
Well, I'm not making any assumption about what we have to do.
Nor am I.
But on the other hand, I would hope we don't have to do too much ruling. So, is there anything else anyone wants?
Candy, I have a
Yes.
conflict on the 29th.
Okay,
Candy,
I have a conflict on the 29th.
I may also have a conflict.
well, we'll talk about that
That's why
later.
there's alternate. Alternate.
Right.
We'll try to figure something out.
Kim, do you want me to go through my PowerPoint?
Yeah, or go for it.
Or wait till the next?
Let's wait till the next.
It's It's late,
When
so,
the rap-
yeah,
Okay?
maybe June.
Could I just say something?
Yes, you could say something.
Thank you, I didn't want to overstep my boundaries. I would just, I understand the convenience and the desire to have all these issues that we face defined so that we have adopted standards against which to weigh this. But I want to remind everybody that the deviation MOAs, if you will, almost by definition are different. And so like Larry said, there's a different set of facts with each one, so that you have to almost have a separate definition for each MOA that comes before you. Excuse me, because of the different circumstances and fact base of the MOA. And I don't think you can always define things, everything, in anticipation of every issue that goes before this commission. And that's been a concern of mine.
I understand that concern, but I also don't want to spend forever on rule changes. So
No, I know.
maybe there's something in between.
I have no desire to change anything.
So I think that for the moment, I'll go to public comment, but please be warned again, talk about process. Only 3 minutes, because if you're going to talk longer than 3 minutes, I'm going to gavel you down and ask you to put it in writing.
Like Thor, you know, like Thor was the time.
Bill?
Can I stand here? Is that adequate?
Can't hear you, I'm sorry, I can't hear you. I have every excuse.
Bill Bordentown, a couple quick points. I think the context you need to establish, which I didn't hear expressed, is that knowledge should be rare and the exception, not the rule, and that policy should be to discourage them. I don't support them at all. I see them as a relief valve to the CMP and that they undermine the plan conceptually and that they should be rare and unusual. And that needs to be part of your thinking. I don't think legally you can do this without rules. Because your existing rules provide for a lack of standards, which I think Commissioner Lloyd made the point that the lack of standards and equivalent protection is what opens you up to challenge, both politically and from a perception standpoint, I think legally as a vulnerability. So have to do with rulemaking. It should be discouraged. I agree with some of the concerns that have already been raised. Again, I'll reiterate, since it will take some time to adopt rules, I think in fairness to the public and to any applicants, predictability is a concern that you should put in place some kind of administrative moratorium on any consideration of any MOAs going forward. And I think you have the ability to do that. And again, I pointed to the Delaware River Basin Commission's actions to do that with respect to their moratorium on reviewing any fracking applications, because they were in the process of modifying their fracking rules, and the rules needed adequate safeguards. You were in the same position, you should have the same approach, and it was legally defensible over there, and it was politically defensible over there, and it was politically defensible against a much stronger interest, which is the gas industry, with billions of dollars at stake in drilling in the Delaware watershed, as opposed to, you know, people running pipelines through the Pinelands. Thank you.
Thank you, Bill. Anybody else? Nothing about the gas line. Please. Any gas.
Mary Ann Clementi Marnigan. Commissioner Ashman, I respect you tremendously, but I really wish you hadn't made that comment to me about nothing about the about the pipeline. I respect the rules that have been set up, and I would appreciate the same respect that I, would understand the rules. Thank you. Is Commissioner Pritchett on the committee? Are there 7 or?
No, he's not. He's
Okay.
an observer, and any commissioner is welcome to come.
So there are
I think there's
5,
5 and 2
6.
alternates, right? 5 and 2 alternates?
One alternate.
4.
2 alternates.
2 alternates. 1 public
commissioner.
No, one commissioner.
Right, 1 commissioner.
Yeah, but there are 2 alternates, 1 commissioner alternate and 1 public alternate, right? And 6 members, full members. 5. Oh, Galecki is also not a member?
I'd be glad to provide you with a list.
Okay.
It's on our website, it's right here. It's on our website.
Okay. So just,
Thank you.
thank you. And I think, so the next meeting, so this committee will meet once a month regardless. So your special meeting
Not
will be.
necessarily regardless, but we will meet probably every month.
Okay.
And the next meeting will be private this time.
Okay, and then I had wanted clarification between private organizations and public.
I don't think we're ready right now
Right.
to give you that.
Thank you.
Anyone else, please? He's a veteran of that committee.
I didn't hear what you said, Commissioner. I didn't hear what you just said.
I said you're a veteran of ad hoc committees.
Yes, yes, I am. So that gives me a special privilege, so I get 10 minutes.
3 minutes,
I have a very brief comment, and that is, as was pointed out here, part of the reason for using the MOA process is the realistic belief that the waiver of strict compliance process is too difficult. But it's been my observation that applicants avoid the waiver of strict compliance process and use the MOA process or other means to get their application approved, even though what they actually do when it comes to the hearings and so forth is try to prove that there is a compelling need for what they want to do and that they can't do it anywhere else. They don't use the word compelling. They use the word, and words matter. They use words like extremely important, urgent, very, very important, and so forth. And I find it hard to parse the difference between, say, equally extremely important and urgent versus compelling. So you have this situation that's sort of a theater of the absurd. To avoid the word compelling, they use other words and use a different process, or try to prove that they have a compelling need. So I think it's maybe important to keep that in mind when trying to figure out how to change the MOA process, if at all. You have this kind of sham situation. And that's part of the overall context, perhaps, in which your deliberations should occur. Thank you very much.
Thank you. Anyone else? Fran?
Yeah, thank you. Thank you, Fran Brooks Tabernacle. I just want to ask, whenever your next meeting occurs, will you be issuing an outline of all of the key issues that the committee will be addressing?
Can I say, hopefully?
Yeah, because it would really help, I think it would help everybody, on your side and on our side. And I don't really want to say that they're mutually exclusive, because they're not, but that there is an overall outline of the key central issues that need to be addressed. And not all of them, because a lot of them emerge. but-
And that will be much easier after we have our meeting with the staff, so I'm not going to promise, but yes, I understand what you're saying.
Okay, well, that's great, thank you.
Can I ask a question? Why is the staff meeting gotta be not public?
Because that's the way we choose to do it.
Oh, it's not a legal issue? Because
It's
you
not.
nodded, you asked the AGs, can I do that?
Yes, I just asked her. She said yes.
But it's not a legal concern.
Not a legal concern.
But what is the concern?
Bill, we are going to meet with staff privately.
But that's arbitrary and irrational.
Just period.
Can I just say one?
Who else? No, come on, Mary.
No, I'd like to clarify what Bill was saying.
No.
It's a working meeting, and I absolutely agree with you that you need to
That's
do
fine.
that.
Thank you.
No, wait, I have one more, please, Commissioner Ashman. Commissioner Jackson had mentioned a point when you were talking about the next meeting. I mean, it's loosey-goosey in terms of the meetings, and I think it just needs to be a little bit more structured. That the people that are alternates are the ones that would fill in for people who can't make it.
If we have a vote,
Commissioner,
Marion, if we have a vote, we will do the count properly. At the moment, it's more informational than anything. Thank you. Anybody else? Now I've sounded so friendly. Sorry, I apologize. It's been a very long day. Anybody on the committee got anything they want to add? Yes.
I just want to comment that I thought Lee's comment was very astute. I think that the history has been that applicants use the MOA process, which is discretionary in the commission, so in essence, very hard to review. To replace a process with compelling public need that has a very high standard and thus could be challenged much more readily if that high standard isn't met. So I think your point is very well taken. Thank you.
Anybody else? Yes.
Do you think it would make any sense to invite the public to submit questions that they think would be important, and we can then decide whether we want to entertain them?
I was making the assumption that if they had such questions, and you're right, they would submit them in writing. I'd appreciate it, because it's much easier for us to deal with.
Commissioner Ashton, what is the best way to get that, the writing to you? Is it through website, through email, regular?
You can email, you can write it on a piece of paper, and if you get it to the staff, they will get it to us.
Nancy, do you want to
Can we have the email address?
Can we name a liaison who will make it easy to focus for all these?
They can send it to Susan.
Or info, not at info. Info@njpines.state.nj.us.
That's the best
One
one.
more time, please.
It's right up
It's right
there.
here, it's info@njpines.state.nj.us. Yeah, if you send it to app info, that's for application related stuff,
Okay,
that's
sorry.
totally different.
Can I ask one question? One
We'll
question?
get it.
One question. Can you tell me the difference between this waiver, what is it, waiver of?
I can spend the rest of the afternoon telling you the difference between a waiver and
And an MOA?
Yeah.
So why do we have the MOAs at all?
waiver. How can I do this? You do it quickly, somebody who can do it.
Well, it is in John's memo, which I encourage everybody to read because it precedes
Yeah.
a lot of things, but my understanding is that through the course of time on the waivers of strict compliance, also compelling public need waivers, they were very difficult to get. By the very nature of their being, they were very difficult to get, and there were some projects that everyone agreed served the public good, but couldn't make their way through the process. So that's why the MOAs were, that's why they were designed and why they were put into place. But I wasn't here when it happened, so that's just sort of the lore I've been told.
I was, and it took forever. And what I would like to suggest is that you read the plan where it says, talks about waivers, because it's very explicit, and it can tell you, these going to help. Thank you. Because they are two very different approaches. Anybody got anything else? Motion to adjourn?
Make a motion.
All those in favor?
The MOA.
Nice to see you.